Hey, good afternoon, everyone. I'm Lieutenant Colonel Pete Combe, U.S. Marine Corps Judge Advocate Division, and I'd like to welcome you all virtually to today's webinar titled The New York Times, the Law of War and Congressional Intervention in U.S. Military Operations. Brian, I think maybe it's a sort of an intentionally provocative title, which you've described as intervention driven by public opinion. I think there are some folks who might characterize as maybe appropriate congressional oversight. Regardless, I look forward to a fruitful discussion on it. Three incidents in particular today are going to frame out our discussion. A series of strikes on the Tabqa Dam in Syria in 2017, an airstrike in Baghuz, Syria in 2019, and then a 2021 strike in Kabul, Afghanistan. These events, the attendant media coverage, they raise thorny questions about the intersection of law and policy, the interplay of domestic law, separation of powers, checks and balances, and congressional oversight with humanitarian law, in particularly law of armed conflict and IHL, and the role of non-governmental actors or non-belligerents like the International Committee of the Red Cross or the media in shaping those aspects of conflict law and policy. This panel will discuss, though, if I'm honest, scratch the surface, maybe a more appropriate characterization. These issues and others, and what I'm sure is going to be a thoroughly fascinating, but unfortunately probably far too brief and potentially intellectually unsatisfying conversation. With that said, to introduce our panelists, first we have Brian Cox, who's currently a JSD candidate and guest lecturer at Cornell Law School and a visiting scholar at Queen's Law in Ontario. He also served 22 years in the Army, including service with Regional Command East in Afghanistan in 2013-2014, which, speaking from my own personal experience, included Wardak, Parwan, Nangarhar, Paktia, and Paktika provinces, which at the time were I'm sure you had plenty of work to do. Brian holds an LLM from Queen's Law School and a JD from the University of North Carolina. Also joining us, we have Dr. Sophie Rondeau from the Canadian Red Cross, where she currently serves as a senior legal advisor on international humanitarian law. She graduated, I won't attempt French pronunciation, from the University of Montreal in Quebec, and holds a doctorate in law from the University of Geneva and University of Laval. She's a member of the Quebec Bar. For the last 15 years, she's been a researcher, guest speaker, and lecturer in various Canadian universities, and she's worked in institutions such as the Diaconia IHL Center, Rights and Democracy, and the Jean Pictet Competition. From Cornell School of Public Policy, we have Dr. Sarah Krebs, who is the John Wetherill Professor in the Department of Government and an adjunct professor of law. Her teaching focuses on the intersection of international politics, technology, and national security. She's written a number of books, including several on drones and drone warfare in 2014 and 2016. She has a BA from Harvard, a Master of Science from Oxford University, and a PhD from Georgetown, and served as an active duty Air Force officer from 1999 to 2003. Our last panelist, Dr. Anna Williams, is currently the Senior Advisor for Civilian Protection in the Office of the Undersecretary, Defense for Policy, which anecdotally is often viewed as the third most powerful person in the Pentagon. She served as a member of the Tiger team that crafted the Civilian Harm Mitigation and Response Action Plan, which kind of colloquially known as the CHIMRAP. She's a military analyst who's detailed to the DoD from the CNA, where she specializes in the employment of U.S. military forces at the operational level of war, which as a graduate of the Marine Corps School of Advanced Warfighting is near and dear to my heart, the operational level of war. She's previously deployed as a civilian analyst with Carrier Strike Group 3 and holds a BS in chemistry and a PhD in chemistry from Northeastern University. With that, we will give our panelists an opportunity to speak. First will be Brian, followed by Sophie, and then Sarah, and then Anna. At the bottom of your screen, if you were in our audience, you'll see the question and answer feature. If you have questions for our panelists, please submit them that way. As the moderator, I'm not sure I'll be able to get to your questions if you try and submit them some other way. So please use the question and answer feature at the bottom of your Zoom window. So without further ado, I'll turn it over to Brian.
Great. Thank you very much, Peter, for the introduction and also for signing on to moderate our event. I'd also like to sincerely thank the American Society of International Law and the Lieber Society of ASIL for hosting our event, or for sponsoring our event, and the National Security Law and Policy Society here at Cornell Law School for co-hosting or co-sponsoring. And also a sincere thanks to the IT department here at Cornell Law School for setting up this really fabulous video production studio and hosting our webinar for today. It's a pleasure to be able to join these very distinguished panelists and the audience for what I hope will be a very fruitful and productive discussion. And so my remarks for today will be drawn from a working paper that is available. Hang on, I'm just going to start my timer here. That is available on the Scholarship at Cornell Law webpage, so you can see the title of it there. And I'll go ahead and have posted in the chat box a link to that paper as well. So my remarks today will be drawn kind of loosely from that project. So the working paper conducts a critical analysis of recent media coverage of U.S. military combat operations under the kind of the broad category of what is described on the New York Times webpage as airstrikes gone wrong. And there are several different components to this broad this broad kind of collection of media coverage. And there's two kind of main themes that come out from the coverage. So the one on the top is more kind of like what I would describe as a human interest story that brings attention and public awareness to the tragedy and suffering that is inflicted upon and experienced by the civilian population in combat areas. And it's a story that isn't very often, it seems to me anyways, very often covered in the media. And so this is a really powerful kind of line or theme that runs throughout this collection of media coverage. The second there on the bottom, so this is drawn from one of the pages that addresses one kind of line of reporting in this collection. And so one of the themes, the second kind of broad theme, is this notion that the U.S. military has been beset for the last 20 or so years of counterinsurgency operations or COIN operations by a condition of scant accountability for the operations that are conducted in armed conflict. And that has been the focus of my research over the past several months, including the focus of this working paper. And so that'll be the focus of my remarks for today. So in the paper, I find that it's helpful, and then I'll go ahead and do the same here for purposes of the presentation, to help kind of frame the discussion by examining some of the ways that the media coverage is used in public discourse. And so here's one example out of three types of ways I think it's used in public discourse. This is kind of just general discussions that aren't really tied to advocacy. It just kind of, just in the public space. And so this is an announcement for a conference that I actually had the good fortune of attending in April on the University of Virginia School of Law campus. And so we can see here from the conference description that the New York Times reports are used as kind of the frame, right? So reports have shown, and then the characterizations or the narratives that are presented in the media coverage are taken as fact. Right, so this report, these series of reports have reportedly shown that the U.S. military is beset by apparent gross negligence and malfeasance if the narratives that are presented in the reporting are taken as factually accurate. And then so this is a kind of a common theme throughout the public discourse, is the sense that someone should be held responsible for the killings, right? So the outcome of the attacks, so the civilian casualties, rather than an assessment of the doctrinal a doctrinal assessment of whether the combat operations complied with law and policy involving armed conflict. And that's in the absence of holding someone accountable for the killings or the outcome, then there's an apparent accountability deficit. And then it raises the conference announcement, raises the prospect that there's questions involving the adherence to international law by the U.S. military if the New York Times reports are taken as accurate, the narratives that are presented in reports. So that's one way, just kind of in general public discourse. A second way that New York Times reporting, primarily New York Times, although there are other media companies that are involved, but the focus has really been, for me anyways, New York Times reporting, is used in civil society advocacy to generate a picture of what needs to happen from outside intervention, typically from congressional intervention or congressional oversight. So you can see there a call for urgent congressional oversight on the basis of civilian harm. And again, it's raising questions regarding the adherence to international law. And again, so in purple, the call for urgent congressional oversight, and then we can see how the media coverage is used. So recent reporting, in this case for the Baghuz strikes and what's referred to in the media very often as the Kabul drone strike, right? So the strike that happened at the end of August 2021, at the end of U.S. military's ground presence in Afghanistan. So it's often referred to as the Kabul drone strike. And so this reporting is used to paint the picture for why urgent congressional oversight is needed. That, in this case, I saw underlined in red here that was flagged as a possible war crime. And so this raises the question of adherence to international law, specifically law of armed conflict, and violation of that, of course, serious violation would be a war crime. And then I've highlighted in the red circle here this notion of accountability. So this kind of runs throughout the discourse in public narratives regarding what needs to happen. So we need to have some sort of congressional or external oversight to bring accountability. But the accountability that, again, like in the conference announcement we just looked at, accountability is being called for repeated civilian harm, rather than an assessment of whether the attacks complied with law and policy involving armed conflict. And then, so the hook here is, so NGOs, folks in civil society have been working with the DoD for years in good faith, and have seen little progress in implementing the recommendations that are presented by civil society. And so the call is now, since those efforts have been unsuccessful, that we need external intervention from Congress. So if we turn to congressional correspondence, so this is a letter that was sent by Senator Elizabeth Warren to the chair of the Senate Armed Services Committee, Senator Jack Reed, in which Senator Warren just draws directly from the New York Times reporting and says, the reports here succinctly describe the scope of the failure. And so the reporting is just taken as factually accurate. And then just like in civil society discourse, the reporting the coverage reportedly raises serious questions about whether the U.S. military is complying with IHL or LOAC, including the responsibility to investigate potential war crimes. And here we have a sense of accountability, or a failure of accountability. And then the call to action in purple here is for the SASC, the Senate Armed Services Committee, to hold hearings to determine whether the strikes in Baghuz complied with law of armed conflict, and to hold people accountable because the military presumably has not done so. So this is another letter that was submitted by a series of 46, if I remember correctly, 46 House members of the House of Representatives, where again the New York Times reporting is used as the catalyst, right? So this reporting has brought to light substantial flaws, and it's up to Congress to get involved. So many of the signatories of this letter went on to form a caucus that looks specifically, that's focused specifically on civilian harm, the protection of civilians in conflict caucus. Now we see here from a part of the press release, so a statement from Representative Andy Kim, who's describing accountability for when things go wrong. And for him, this description, when things go wrong, is when civilians are harmed in armed conflict. So again, we're focusing on the outcome of attacks and getting accountability, seeking accountability. And in this context, when things go wrong, that's when civilians are harmed, and we're looking for accountability for that. And so on the civil society, kind of flipping back from Congress to civil society, we see that that Civic has thanked and expressed gratitude for Congress playing a critical role in championing legislation that's focused on civilian harm. We're calling accountability for the condition of civilians being affected by conflict, but not really assessing a doctrinal sense of accountability by applying law of armed conflict and rules of engagement and other use of force law and policy. So the two kind of main themes that run through both the public discourse, one on top there is that the New York Times reporting has brought to light these substantial flaws. And then the second is that there's a lack of accountability for civilian harm that needs to be addressed from external oversight. If the DoD isn't going to take these recommendations, then it's up to Congress to step up. So that's how an overview of how these narratives we see them used in public discourse. So now I'll transition to the three case studies that I engage in the working paper, but I'll actually take them in a different order than I present them in the working paper. I find that's useful because we'll start in the middle here with the Baghuz strikes, because the Baghuz and the Tabqa Dam strikes, the narratives in media coverage are focused on a kind of a doctrinal characterizations of accountability and presenting this idea that the military is not complying with its doctrinal responsibilities. And then we'll address Baghuz and then Tabqa Dam, and then we'll come back to the Kabul drone strike as the first case study in the paper, but I'll address it third here. All right, so starting with Baghuz, the coverage of the Baghuz drone strike, or the airstrikes in Baghuz. So we see that our protagonists in the reporting are posted at the Al-Udeid Air Base in Qatar. And so this is what's referred to as the Combined Air Operations Center, which we'll actually get kind of an inside look here in just a moment. So folks at the KAOC in Al-Udeid saw some footage of a drop, an airstrike. And according to the reporting, there was confusion as to who dropped it. And we believe at the time from the KAOC that up to 50 women and children may have been injured or killed or affected, certainly in the airstrike. So the reporting later goes on to point out that the number of dead, the casualty count was assessed to be around 70. And it was flagged as a potential war crime that needed to be investigated. Flagged from the KAOC, from the analysts and from the legal advisors there at the KAOC. And here's our accountability hook. All right, so because this strike happened and the military did this stuff, so it downplayed the death toll. Reports were delayed or sanitized or classified, and just in general, this paints the picture that the U.S. military is not holding itself accountable. Right, so if we dig into the narratives a bit that are presented in this particular New York Times story, so we see one of our protagonists and one of the representatives in the IG or Inspector General's office, Gene Tate, says that the military seemed just intent on burying this strike and the outcome. He criticized the lack of action on behalf of the military kind of senior leadership. And eventually he was forced out of his job for this criticism. And so we've got this sense that's created that we have a whistleblower who's trying to get the military to do the right thing, and the military is not doing what he thinks needs to be done. And eventually he's pushed out of his job for just trying to get the military to hold itself to account. We also have in the story an Air Force lawyer who we'll see here in just a minute, who after the strike ordered the air crews to preserve the video evidence. And because this is a potential violation of law of armed conflict. Now, not all violations of LOAC are war crimes, but in this case, this could potentially be a serious violation, and so very well may qualify as a war crime. And so we know that from the reporting that there was an assessment done from the same ground unit that engaged in the strike, and that there was no formal war crime notification or criminal investigation. Now, I've put the maroon arrow here at the deaths were accidental because there are occasions in the reporting and the actual story itself, and this is one of those occasions, where we see that some of the factors that are presented in the reporting actually indicate that, you know, if we took these at face value, that the strike in this case wasn't actually a war crime, right? So we know, at least from the reporting internally to the New York Times story, that they were told that the deaths were accidental. And if we took that at face value, that, as we'll see here in just a moment, that would negate the prospect that there's a war crime, unless, of course, there's, you know, the prospect, setting aside the prospect that the ground unit is just lying about what the ground force commander believed. Right. So here's our Air Force lawyer from the KAOC, Lieutenant Colonel Dean Corsack, who notified the chain of command of a possible war crime, notified leadership and Air Force criminal investigations, notified the Inspector General, didn't get the resolution that they were seeking from the players at the KAOC. And so eventually Lieutenant Colonel Corsack went out to SASC, the Senate Armed Services Committee. And eventually it seems from the reporting that the analyst, Gene Tate, who was removed from the IG office, ended up taking it to the New York Times, the media, as a source. So the first thing, for folks who are knowledgeable about the doctrinal application of law and policy and military operations, specifically the KAOC, this is one factor that should raise concern with the correctness, the veracity of the narratives that are presented in the report. So we've got an assessment coming from the KAOC. The Air Force lawyer, Lieutenant Colonel Corsack, after viewing the footage, right? So this should be the first kind of red flag that gets raised in terms of the assertion that this is a potential war crime. Because so we see here, this is an aerial view of the KAOC, or of All-You-Need Air Base, where the KAOC is, down the lower right of the screen, and then upper left is an aerial view of Baghuz, where the strikes happen. So if we pan out a little bit from these aerial views, we see that the Qatar, the air base at Al-Udeid, is down in the lower right-hand portion where the little gray pin is, and then Baghuz, Syria, is up where the red pin is. So you can see it's quite a bit of distance away. Now, this should raise some concerns for folks who are familiar with operations of the KAOC, because so we see there, this is the KAOC. The blue arrow, incidentally, is where the lawyer's desk is. So if the setup is the same as what I'm familiar with, that'd be about where Lieutenant Colonel Corsack's desk would have been if he were on the operations floor. So the KAOC itself is described as the nerve center for all air operations that occur in theater. So the KAOC plans, monitors, and directs sortie execution, right? So if we're sitting from the KAOC is the operational bridge. So it integrates and synchronizes all air operations. It's kind of the bridge between strategic level, policy and directive down to tactical level execution. But the KAOC itself is not responsible for tactical level execution. That's just part of Air Force doctrine. So we see here that mission command is exercised through centralized command, distributed control. So the KAOC would be the aspect of distributed control, and then decentralized execution. So that would have been the control on the ground. And it's common to say in the Air Force that flexibility is the key to air power, and doctrine is this portion of doctrine really sets that up. This is where the flexibility comes from. And so at the KAOC exercising distributed control, they're not really in a position at the KAOC to assess what the intent or the knowledge of the ground commander was at the time of the strike. Now, the controversy here seems to involve the LOAC proportionality rule, right? So the report that was done, the investigation or whatever it was that was done by the ground element resulted in what Tate described as an impossibly small number. So this would be, in the initial assessment from the KAOC it was around 70 or so civilians that were potentially kill them with strike. And so what the controversy here is the low act proportionality rule. So we know from a secondary review that occurred after this story broke. This was from General Michael Garrett, who at the time, I'm not sure if he still is, but at the time was the U.S. Army Force Com commander. We know from the ground reporting that the ground force commander was not aware that civilians would be affected by this attack. And so if we apply, it doesn't really matter which source from which we draw for a doctrinal assessment of or doctrinal description of the low act proportionality rule, whether it's AP1, that's Additional Protocol 1 of the 1949 Geneva Conventions, which the United States has not ratified, but this is an articulation of the proportionality rule that the United States would consider to be an expression of customary law, or whether we go to the Rome Statute that has a provision involving the proportionality rule, or if we go to the doctrinal, like kind of military doctrinal utilization or implementation of the proportionality rule. We know that what we're focused on is what the ground force commander in this case, or whoever it is responsible for the attack, what they expected, what their knowledge of incidental damage was. And so in this case, and then we also know from doctrine that we have to assess compliance based on the information that was available to, in this case, the ground force commander at the time. The ground force commander, as we know from subsequent reporting, did not expect any incidental damage, and there had no knowledge that that the attack would cause incidental damage at the time. And we saw that a bit from the New York Times reporting, where it says, it emphasized that the ground force commander or the ground force that investigated the incident determined that it was the incidental damage was accidental. Right, so we know that from the reporting, and we also know that from subsequent investigation. But regardless, there's no way to tell from the CAOC it's not the responsibility of the CAOC to determine what the ground force commander expected. Right, so if we go to the DoD Law of War program, this is the DoD directive that establishes the program. We do see that a potential law of war violation is a reportable incident. So it does have to be reported. It does have to be assessed. But it seems that actually happened, right? So if no one else did, certainly Gene Tate and Lieutenant Colonel Corsack did, notify the chain of command. So this was complied with. But the reason there wasn't a subsequent investigation, it appears, is that the ground force commander wasn't aware that any incidental damage was going to come from the strike, and therefore it wasn't a war crime. So there's no credible information to suggest that a war crime was committed. So it's not that superiors didn't open an investigation. It's just that they looked into it, and for the folks from the CAOC were mistaken about their belief that they could assess that an excessive amount of incidental damage that occurred in an airstrike could, from that assessment alone, without knowing what the ground force commander believed at the time, that they could assess that a war crime had been committed. And so Gene Tate, it seems, was escorted from the building based on his advocacy for pursuing this war crimes narrative, but it appears from the reporting and from subsequent investigation that it was unfounded from the very beginning. But the key takeaway is, if you're familiar with the way the CAOC works, and if you're familiar with the reporting, you would see that that an analyst or a legal advisor from the CAOC is not in a position to assess what the ground force commander anticipated at the time of the strike, and that's what is really we have to be focused on in terms of the proportionality rule. Okay, so I'll be a bit more brief when I cover the next two case studies. So this one involves the Tabqa Dam. So there's two main claims that arise from this story. One is that the top secret Task Force 9 group that was operating in support of the Syrian Democratic Forces, or the SDF, circumvented the rules involving the no strike list, and that they circumvented the rules They manipulated the rules involving self-defense, rules of engagement self-defense, in order to circumvent the more lengthy approval process that would have to go through to actually strike this target. So those are the two main claims. And this is accurate, right? So if the dam is on the no strike list, there's no reason to believe that it wasn't. That normally, unless an exception applies, there would have to be pretty high up on the chain of command, actually, an approval that's sought and approved and achieved before the dam could be listed as a target. And the ISIL fighters are there could be struck. Now, one thing I did mention is that that is the standard procedure unless an exception applies. Now, this is another example where we see from the reporting that if you're familiar with the doctrine, you can see that actually an exception does apply, and that the ground force, the ground element, in this case, Task Force 9, didn't actually circumvent the rules involving the no strike list. So for here, we'll go to what's available right now in open source, which is the Chairman of the Joint Chiefs Instruction 3160.01 alpha or 01A. Sorry, I try to avoid using military jargon now that I'm out of the military, but this is an occasion where it just doesn't sound authentic to call it 3160.01A, so I'll refer to it as alpha. So the 3160.01 alpha that's available, this is the 2012 version. There's since been several updates. Right now we're on CGCSI 3160.01 Delta, which was released in May of 2021. It's not available to the public, but this version, the ON Alpha, is, and the guidance involving no strike list is substantially the same from one to the other. So we see here that there are two exceptions from the general kind of rule that you do have to go for higher level vetting and approval before you strike an NSE, something that's on a no strike entity. So it's on the no strike list. One of those is that, and it's a conjunction here, that we know that the dam is being used for a military purpose and that it can be nominated as a time sensitive target or a TST. So we know from the reporting that that was being used as a military purpose. In fact, the reporting refers to it as a fortress. ISIL was using it, ISIL fighters were using it as a fortress. So we know from the reporting that it was used as a military purpose, and we can suppose from, again, factors that are presented in the reporting that it was a TST or time-sensitive target. And you can see here the glossary of the ON alpha in this case that describes what a TST means. It defines TST. So it's something that poses a danger to friendly forces, and we know from the reporting that it did. And so on the face of the reporting, we can see that one of the two exceptions for the higher level reporting or vetting for attacking a no strike list actually applies. And then so the second, and we'll see some more indications about why that is, about why it was a time-sensitive target. When we convert over to the self-defense, right? So we do know from the reporting that there was a standoff between ISIL and SDF. The SDF tried to take the dam, and they suffered some heavy casualties. And we know from the documents, it seems that the investigative reporting team were able to get from a FOIA request that the attack was justified by self-defense. And so we know, again, from the reporting that the self-defense provisions, if we turn to those, so this is established in CGCSI 31.21 or 3121.01 Bravo, which is the Standing Rules of Engagement, ESRO. These were published in 2005. They are still available in the public sphere. So if we had access to the classified operational rules of engagement, we could get more specific on what those ROE were. But having access to the SRO is fine, because the all operational ROE refer back to the SRO, the unclassified SRO, for definitional purposes. So we know from definitional purposes that to qualify for a self-defense engagement, so hostile act I left off here because we're not sure if at the time of the strike there was a hostile act, that's an attack or use of force. But hostile intent is a threat of imminent use of force against either U.S. forces or other designated persons. We can presume that the SDF qualified for other designated or extended self-defense. And so if we go to the definition for imminent, we see that it's a decision that can be made based on all the facts and circumstances. A call can be made at any level, and an imminent does not necessarily mean immediate instantaneous. Once something does qualify as an imminent threat or a hostile intent, hostile act or hostile intent, U.S. forces could use all necessary means to reduce that threat using the self-defense rules of engagement. And so we see here that yes, from the reporting, the dam workers, if we go back a slide, the dam workers reported there was no heavy fighting on the day of the strikes. That's a bit of a red herring. If the ISIL fighters were still there on the dam, using it as a fortress. The SDF fighters have taken heavy casualties. We can assume that the ISIL fighters still presented a threat of imminent use of force, such that the self-defense rules of engagement applied. And so it's not the case that, as the unknown or unnamed source that's quoted in the story claims that it was a stunning departure from how an air war is supposed to work, and that the Task Force 9 operators bypassed safeguards. If we apply the actual doctrine that applies to no-strike entities or no-strike list and self-defense, we see why there was no disciplinary action that was taken. And then our accountability hook is, well, because no action was taken, this task force just continued to use or abuse these safeguards to continue to strike targets, when in fact it's the reporting doesn't actually establish that Task Force 9 did abuse any of the rules of engagement or other use of force policy. All right, so turning briefly to the Kabul drone strike, I ended the case study here for the presentation, but I started the working paper with this, but I wanted to end here because this is a bit of a different style of accountability. This isn't doctrinal claims about the no strike list or the rules of engagement. This is just kind of this general idea of accountability. So this particular story, there are several in this line of reporting. This particular story starts off with a quote from John Sifton of Human Rights Watch, who describes, this is just another example in decades of failed accountability. And because of that, the hook is we need external scrutiny and to impose vital reforms, because the military is beset by decades of failed accountability. But there's no real description of what the failed accountability is. It's just kind of the outcome of the attack. And so if we go to another source that's drawn kind of more in the middle of this story, is a Twitter thread from Luke Hartig, and I'm familiar with Luke's work. I respect his work immensely, but there's no description here on what he means by the military bungled fundamental operational things, or that there's massive flaws. Like, this is just basically, this is a portion of a Twitter thread that's making conclusory statements and not describing exactly what it is that was the operational things that were fundamental operational things that were bungled. So it's kind of a questionable source in terms of analysis, and which you can expect because it's it's a Twitter thread as a source. So then this story closes with again a tweet from Senator Chris Murphy, calling for accountability for the drone program chain of command, because if there's not accountability seemingly from the outcome of attack, then the drone program chain of command is going to think that killing kids and civilians will be tolerated. So this is just a general sense of accountability. It seems based on the outcome of the strike, without an assessment of the fundamental operational things that actually went into the attack. So we know from the reporting and from the press release, or the press conference, and some of the subsequent reviews that were released to the public, at least the summaries thereof, we know that the strike complied with the LOAC distinction and proportionality rules, in that the personnel responsible for the attack did not believe that they were going to inflict civilian casualties at all. They mistakenly believed that they were attacking ISIL, vehicle-borne IED and ISIL operatives. So I've pulled out this paragraph from a press briefing from General McKenzie, who was at the time, Ken McKenzie, who was at the time the CENTCOM commander. So if you read through this paragraph, and then kind of throughout the transcript of the briefing, you see what can be characterized, depending on your perspective, as feasible precautions in the attack. These are precautions that the personnel involved in the strike took in order to try to mitigate civilian casualties. And so these would be considered fundamental operational things that actually potentially complied, depending on your perspective, with the LOAC feasible precautions rule. But regardless, we are required to assess, as the DoD Law Board Manual points out, assess decisions based on the good faith. Decisions must be made in good faith based on the information that's reasonably available to the personnel at the time, not on the basis of hindsight. And so that's kind of the three case studies that we see, that In the working paper, I expand beyond those case studies a bit, but we can see how the media coverage is used and how this notion of accountability is presented in the reporting, right? So we focus on the New York Times has brought to light an apparent lack of accountability, whereas if we actually apply doctrinal sources of law and policy, we see that there's not actually a condition of scant accountability. So just to kind of close out my remarks here, I want to put this kind of in a broader context and explain at least this is an area that I've been interested in since I left the military. I understand that there are different conversations that are happening with folks who are involved in the civilian harm and civilian mitigation harm space and in the military space. And I want to try to highlight and understand different perspectives of what we mean by this notion of accountability, since it is such a prevalent theme that runs throughout this reporting and this discourse in general. So if we come at it from a military perspective, so this, you can see here the mission of the DoD. Underneath the DoD, we have 11 combatant commands, 7 geographic and 4 functional, though I'm not sure what's going to happen with Space Command now that Space Force is being stood up, but we'll see how that plays out. But so currently we still have 11 combatant commands. So if we look at, if we take the mission of the Department of Defense, and then we look at a couple of combatant commands. Here I've drawn from the mission of EUCOM, so U.S. European Command. And we see that their mission statement is, we partner with allies, you can see it there, and then should deterrence fail, we are prepared to fight alongside allies and partners and prevail in conflict. And then I've also drawn the vision from U.S. Special Operations Command, or SOCOM. Their vision is that they will put Special Operations Forces professionals out in the field who will compete and win for the joint force and the nation, right? So this is kind of the mission set for these combatant commands that is nested with the DoD mission. From this perspective, if we look at some relevant provisions of the DoD Law of War Manual, we see that protection of civilians is one main purpose of the law of war, but it's not the purpose of the law of war. The law of war exists. So this is a really good excerpt from the Law of War Manual. So the conduct of the law of war, like the conduct of hostilities, in complying with the law of war, can be understood to reflect what states have determined ahead of time as conduct that is militarily unnecessary per se. Right, so that's how the military sees compliance with an application of LOAC, which is why the military's personnel are assessed based on a good faith basis of the information that's available to them at the time, regardless of the outcome of a strike. Because the information that's available at the time is not always going to be perfect. So if we transition to more of a civil society, at least civil society groups that are active in this space of public discourse, so we can see the mission statement that I've drawn, or the vision that I've drawn from the Civic website, where Civic envisions a world in which no civilians are harmed, and their version of accountability is trying to address civilian harm, right? So there's no requirement to apply a doctrinal sense of law or policy. It's just holding folks accountable for the harm, for the outcome of the attack. And so folks from Civic feature prominently in New York Times reporting, and also draw from the New York Times reporting for their advocacy, as well as so too does PAX. Right, so we can see from PAX the whole purpose of PAX, according to the website, is to reduce civilian harm, right? So there is no kind of military necessity on the other side of fighting alongside partners and allies to win on behalf of the nation or the joint force. It's just the purpose is to reduce civilian harm, and accountability is assessed based on that harm. All right, so I just realized that I'm going to have to go ahead and skip a bit, which I probably should have done earlier. I just had an eye on the time. So let me go ahead. I think I've addressed enough for accountability. With apologies, I should have been paying more close attention to my time frame here. So we can see a lot of the narratives that are drawn in from members of Congress are actually drawn directly from civil society advocacy, without an assessment really of whether these narratives almost verbatim from civil society advocates without an assessment of whether these actually comply with the interests of the DoD. Right, so kind of the back end, the kind of to complete these remarks, we can see here that the scan accountability narrative that's presented in the New York Times reporting is actually doesn't exist if we apply doctrinal sources of law and policy, which we might expect from investigative reporters who are exercising the role as the fourth estate to hold the government accountable. All right, so I think with that, I'll go ahead and stop sharing screen and turn it back over to you, Pete, with apologies again for running well over time.
So Brian, thanks for that. It's a fantastic rundown of a number of different vignettes and really a deep dive into the law and policy applicable from sort of a DoD uniformed operator perspective. And I'll use some military jargon as well. You've given the rest of our panelists an awful large target to shoot on, as it were, which may be inappropriate to say for our next panelist. I would invite Dr. Rondeau. Any comments that she has in particular, or again, if you care to address any of the points that Brian has made. So over to you.
Thank you very much for the introduction. I first want to thank the American Society of International Law and its Libre Society for hosting this important event. And I want to especially thank Brian Cox for the kind invitation. You're bringing together complementary perspective and having those discussions. I think it's a privilege, and it's also the reason why we engage into, whether you call it LOAC, IHL, of law or war. That's the kind of discussion that we want to have. So I want to thank the organizers and the people that made this moment possible. Although most of the views that I will present here, if not all of them, will align with my professional affiliation, it's important that I mention to you that I'm not presenting here the position of the Canadian Red Cross, the Red Cross, Red Crescent movement, or the International Committee of the Red Cross. These are my own reflection as an IHL researcher, especially, this is important that I mention it, since once I'm a civilian, so I have no military training, and two, I'm Canadian, so I have no legal training in American domestic law. So my presentation will be anchored into international humanitarian law, and I'm looking forward to engaging with the other panelists on this subject. I have been asked to explore the virtues and the limitation that are inherent in depiction developed in media coverage of military combat operation, and I will do so by proposing what I call a humanitarian impressionist take on the legal impact of media coverage of military combat operation. So what's on the menu for the next 10 to 12 minutes? I have one legal fact, one missed opportunity, and one virtue that is kind of dressed up as a limitation. That's going to feed into the question period, and I think that Brian really set the stage with a lot of details on some of the issues. So if you want to discuss that more in depth, we can do it afterwards. I'll try to keep my remarks short to trigger and nourish the discussion. So the first element is the legal fact, a pretty obvious one. IHL, so International Humanitarian Law, or you can call it LOAC of law of war, is the alpha and the omega. Or to be a little bit less dramatic, IHL is the applicable body of law in armed conflict, and that's the main anchoring point. So pending US or any domestic legislation that's intended to here address DoD civilian harm mitigation practices, if passed, should and must be understood and implemented under an IHL perspective in terms of legal obligation. That's the body of law that addresses all the actors, from the international community to Congress, Senate, the state apparatus itself, the United Nations. That's the anchoring point. I'm not going to go over the three principles on conduct of hostilities. Brian did mention them. We all know distinction, proportionality, and precaution. But I do want to say that if we're looking at issues such as misidentification of legitimate target, it would be looked at under the lens of the principle of distinction. If we're looking at minimizing war unintended casualty, then we're looking at proportionality and the notion of collateral damages. If we're looking at mitigation, well, we'll be looking at that from the lens of precautions. IHL is a sophisticated and context-specific balancing act. So it's not just humanitarian law, it's humanitarian imperative versus military necessity. And it's always within the context, finding the right balance between the two. So it's something that's, as I said, very sophisticated and very context specific. I can dab a little bit here into lex specialis. IHL is the law that governs the assessment of the lawfulness of the use of force against lawful targets in international armed conflict. So, in our specific context, when US armed forces are mobilized in the context of an armed conflict, it triggers the law applicable to an IAC, an international armed conflict. So, we can mobilize lex specialis. That's a Latin term that is derived from a legal maxim that we use in interpretation of law, both in domestic and in international law. It essentially means that more specific rules will prevail over more general rules. So the rules that apply in the conduct of hostility, meaning the rules of IHL here, will be the one that are going to apply in this specific context, even when you're looking at policy or other issues. So why am I stating what seems to be the obvious? Well, I'm anchoring this opening comment in 3 documents that are linked with the New York Times coverage and also the different reaction from state bodies to that, what we can call campaign of coverage of those 3 interactions that Brian mentioned. The first one is the November 30th, 2021 letter that was signed by 24, we can say, civil society organization, humanitarian organization. This letter was sent to the leadership of the US Senate and the House committee, and it was calling for urgent congressional oversight of US civilian harm policies. It also did mention and adherence to international humanitarian law in light of the recent strike. So hooking that congressional oversight with IHL was already something that was put forward in the letter by the civil society movement, by those non-belligerent actors, as it was referred in the opening comments. So IHL is always present and will be the anchoring point. The second document I want to mention is the report that came out in April 22 on 2022. There were 8 recommendations made by 7 US senators to be addressed in the Department of Defense Instruction, the Center of Excellence, and the Civilian Arm Mitigation and Response Action Plan, which I'll refer to as the action plan. We do have an expert on the panel, Dr. Williams, on that, so I'm looking forward to having discussion on this. So coming back to the report that was made public in April, one issue was looking at targeting procedures. So the recommendation reads as follows: the senator believe it is crucial to examine targeting procedure to ensure that tactical and operational improvement comply with the law of armed conflict, including the principle of distinction and proportionality. So you can see that even if we have overarching other consideration, IHL is always brought back because that's the common language that we have for the international community, but also for the state apparatus. The third element, so you have one from civil society, the letter, you have the recommendation by the senator, and you have the action plan itself that was made public in August 2022. I do want to bring your attention as a researcher, we always look at the footnotes. The plan of action starts with a very important footnote, and that might be something that we'll discuss in the question period, but I want to read it to you because it brings it back. It brings IHL home into that action plan. So nothing in this plan is intended to suggest that existing DoD policies or practices are legally deficient or that the action to be implemented pursuant to this plan are legally required, including under the law of war. The US military routinely implements heightened policy standards and processes that are more protective of civilians than and supplementary to law of war requirement without such standards and process modifying or creating new legal requirement. So it really anchors everything around IHL. I think this footnote speaks volume, and if we want to discuss it, I would be more than happy to talk about it. So that was my first element, the legal fact. The second one is a missed opportunity, and I'm going to be very short on this one, and maybe it's more in a form of a question, as this is not necessarily my field of expertise in the American theater of operation. In the action plan, as well as in the Center of Excellence for the Protection of Civilians, there's no mention of collaboration with civil society organization. So you probably heard the sentence before, nothing about us without us. That's a slogan that's used to communicate the idea that no policy should be decided by any representative without the full and direct participation of member of the group affected by the policy. Here we're talking about protection of civilian organization, humanitarian organizations such as the Red Cross movement, but other actors from civil society do have expertise, knowledge, capacity, and also relationship build in communities to actually support those actions. I know in the action plan, we're talking about development of tools, training, advancement of knowledge, professional military education. I know these are all areas where the Red Cross has expertise. This should be considered as a collaborative potential, as having a lot of collaborative potential for collaboration in this area. And unfortunately, from what I'm looking at the document, I'm not seeing that being put forward. So I do see that as a missed opportunity in the actions to come out of this situation. My third and last comment, so I'll put us back on schedule on this one. I want to talk about a virtue that's kind of dressed up as a limitation. So very briefly, I want to look at the impact, the role of media, because we're anchoring it in the coverage of the New York Times, and more specifically, the role of media in shaping public opinion. So in situation where we have high profile media coverage of military combat operation. And I'm bringing the big guns for the end. I'm taking out the three-headed monster. It's not Cerebrus, but it is the Martin Clause. And I want to look at the dictate of public conscience. It's one of the elements of the Martin Clause. As you know, we can find the Martin Clause in Geneva Convention, so at 63, 62, 142, and 148. That's the common article. We can also find it in Article 1 of Protocol 1 and in the preamble of Protocol 2. Martin Clause reads as follows, language just vary, but in cases not covered by black letter law, civilian and combatant remain under the protection and authority of the principle of international law that's derived from established custom, the principle of humanity, and from the dictate of public conscience. So that's why I'm calling it the three-headed monster. You have custom, you have principle of humanity, and you have the dictate of public conscience. So what's the role of dictate of public conscience in developing IHL, in making new law? And I want to kind of tackle that interaction between policy and law through that clause that we find in black letter law that's referring to a situation that is outside black letter law. So I want to take a look at that element of the Martin Clause, adopting Meron's perspective. He says that dictate of public conscience, they can be examined from at least two perspectives. The first one is they can be seen as public opinion that shape the conduct of the parties to the conflict and that promote the development of international humanitarian law, including customary law. The second version, which I'm not going to tackle here, but I'm sharing it to you because I'm adopting the Meron perspective, is that the dictate of public conscience can be seen as a reflection of opinio juris. We don't have 45 hours to tackle that, but that is something that is also interesting. But I really want to focus here just on the dictate of public conscience being assimilable to vox populi. They can be identified in the motivation. We can call it a sense of abhorrence, a sense of repugnance. And Brian mentioned it. The first angle that he mentioned, I think it was terror and I can see my notes here, tragedy, suffering. So that would be the vox populi, the sense of abhorrence that you get from public opinion. This can lead to the conclusion of legal instruments under international humanitarian law. That's something that's possible, and it's even something that's captured in our conventional instrument. That being said, the dictate of public conscience by themselves, they're not law, but they can play a very important role in the interpretation and the determination of IHL rule. So public opinion has a fundamental role to play in the development of international law, but it can only do it if it interacts with the other sources, namely customary international law or treaty law. So there is a key role, but it's not a standalone source, and Vox Populi, public opinion, cannot necessarily create law as itself. So I want to quote Thurer here on a sentence that I think gives a good context to my comment. So public conscience may be, and very often is, a moral impulse calling for criticism or condemnation of abuse of power as well as for reform. It is not, however, always an enlightened or a reliable guide. So a direct and explicit connection of the dictate of public conscience, the requirement of the public conscience to conventional or customary rules, I think is necessary to avoid a shift toward natural law or even pure morality, even if the role is definitely essential in our society. It brings back the dynamic elements, the push and pull between military necessity and humanitarian consideration. I think that public opinion played by the media will help us find that right balance, and it's one element that needs to be considered. So in other words, public opinion can play a role among the sources, not just of IHL, but the whole body of public international law, but only if they are included in a treaty. So alone, they do not possess that capacity to actually change law. So I hope these comments will feed into the conversation. I'm very much looking forward to hearing the two other panelists and exchanging with you at the question period. Thank you very much for your attention.
Thank you very much, Sophie. I find your last comments on the role of public opinion and its connection to the development of policy, the shaping of or not shaping of customary international law and eventually treaty law. I find those to be really interesting concepts. I think they lead nicely, frankly, into Dr. Kripp's comments on the intersection of international international policy, national security, and the like. One administrative note I would offer. I know that we are scheduled for 90 minutes. We are not limited by technology, so if anyone needs to drop off at the 90-minute mark, then certainly do so. But we are not going to be required to drop at the 90-minute mark if anyone is inclined to stick around. So with that, Dr. Kripp, over to you.
Thank you, Peter, Brian, Sophie, Anna, and the American Society of International Law. This is a topic that I have thought about and worked on for now close to 2 decades, because as my military colleagues know, we are always being trained in the law of armed conflict. And I think this is something that, notwithstanding, very visible and egregious strikes like the August 2021 event, I think that this is something that the military has attended to. However, and I want now to dovetail off one of the last comments that Sophie made and that Peter teed up for me as though he knew what I was going to say, even though I didn't share my remarks ahead of time, that role of public opinion, because that's something I've worked on quite a bit. And one of my concerns as someone who now is also out of the military, but has thought about this from an academic perspective, both theoretically and empirically, is the concern about policies like counterterrorism drone strikes that are technically mostly under covert action Title 50 authority, but have been carried out for 20 years. And my concern kind of normatively and both from a domestic and international legal accountability perspective is how can the public weigh in on policies that they're sort of apprised of? And so what I wanted to do in my comments today is actually present a bit of empirical work I've done on this topic, not just on the question of public constraints on the use of force, but also the role of the legislative branch in executive checks, as well as the media. So I'm going to just share my screen here. Can everyone see this? Everyone. All right. So yeah, and one quick sort of aside here that I was thinking about as Brian was talking is it reminds this literature, his contribution reminds me of the literature in the 1990s on the CNN effect and the role that it was driven kind of by one big kind of visible CNN story on the shooting down of the Black Hawk in Mogadishu, and the pretty clear sense that really undermined the public's appetite, Congress's appetite for conflict, and drew an end to the conflict. But what was interesting about that literature is it didn't last very long, and it was almost like it was a one-off thing, which doesn't mean it wasn't consequential, but it was this question of sort of, can we generalize from one episode? And I would say here on this New York Times, the August 2021 coverage, it seems pretty clear that coverage had a one-to-one effect on the military, on a number of policies within the military, not least sort of standing up this civilian harm institute. So I want to just kind of concede that ground. So I'll get through this as quickly as I can. I know Peter just said we could stay here all day, but I know we're all busy. So I'm going to try to keep as much time as possible. But I did, as a sort of flexibility is the key to air power, while Brian was talking, I did add this chart because I think this is really important conceptually for thinking about what we're talking about. So when we think, and I come at this from, I teach in a law school and I teach international law in the use of force actually right now. I have a class on that, but I'm also an international relations scholar. So I always like this chart because it puts these different actors into context. And so we have the role of events on the ground. We have those events being kind of represented and reflected and refracted through the media. The media then is being picked up by public opinion. And you can really see the kind of inner linkages here, then the public opinion. Sophie was talking about the role of public opinion in international law. Where I think that role is important is in influencing in a kind of abstract public mood kind of way, how decision makers think about these policies. This is something that the former DCI had said, which is you can't carry out policies, these drone policies, for a period of 20 years without some kind of public endorsement or sanction. And so I think that's where this is relevant here. And you can see these interlinkages. And where I thought this is what I think is really important here from the role of the media is, and I think this is different from how Brian is thinking about it, but I just want to offer my own take. The media on these quasi-covert actions like drones, how do we know what these events are on the ground if they're not covered? So in kind of in the traditional literature, there's this sense that, well, casualties are represented, or kind of in the media's discussion of casualties is then affecting public attitudes toward the war. The public then is creating these constraints on decision makers. But what does that look like when you have these covert actions that are kind of quasi-public and not? So that's kind of the focus of some of the recent work I want to talk about, which is how do both, and there are two parts here. The most recent work is on how individuals, and I'm adding in public and the public and elected officials form opinions on military action. And one of the things that I've been very interested in is on the drone program, the way in which is it information about the program that affects how people think about it, or is partisanship kind of standing in as a proxy for and as a cue for them? And then we conducted a couple of different studies, surveys on that first question to look at public attitudes. But I also want to talk briefly, looking at the time here, it will have to be really brief. We have, with co-authors, Doug Kreiner, scraped the congressional record of legislative floor debates to try to understand whether this is a separation of powers question or a separation of parties, which is a concept that has been that is part of kind of the constitutional law use of force literature. So the party effects here are really, I think, notable, and I'll get to those, I think, in a few minutes, but really just kind of looking at, essentially, are Republicans more likely to, are they sort of consistent in their pro-hawkish policies, or are they more likely to kind of check the role of the president when they're in the opposition? And that's kind of what we're looking at, is kind of the separation of power, separation of party kind of questions. What's been interesting as a case study here is the US drone program, because the US has used drones covertly since 9/11. And what I think is unique about this form of covert action, and again, in the constitutional law kind of use of force literature, there's a lot of conversation about how do we think about checks and balances on covert action? And the literature on this, it tends to focus on, you know, the Iran-Contra, these one-off, or the Bay of Pigs kind of one-off episodes ex post. So how do Americans, what do these accountability linkages look like, where these policies are taking place over 20 years, hundreds of attacks, if with a kind of sporadic coming to light of these strikes. And so they're taking place all over the world. And yet, you know, how can they make sense of these? So public opinion, as I said, kind of at the outset, has focused on events, the relationship between events and debate and oversight. But it assumes that there's this kind of unmediated relationship between events and what people see at home. And usually that literature focus on either the financial costs or casualties. Covert action is really a unique case. Again, the literature is focused on these one-off episodes like coups, and often kind of unobserved effects that are disclosed after the fact. And drones are really, they're consequential, and they're kind of a conceptually weird hybrid. And so we've conducted quite a few studies, both on the public and on Congress, to better understand these different accountability linkages on the executive policy. I don't want to go through all of these because it would take quite a bit more time than we have. But the main thing is to say, to probe the question of, in the absence of information that is kind of fluidly present between kind of the events on the ground and the public, is partisanship, which is a significant thing, at least in the United States, is that standing in? And what about the role of that information, these events on the ground, and public support? So we've done, as I said, a number of different studies on this. So we recently collected data. In the 2020 Congressional election study on public attitudes towards drone strikes, we conducted a number of different surveys looking at partisanship and control. And then an original survey experiment as well. And then the second part of this is that we've looked at the role of Congress. And so members of Congress have said, look, we're, the gang of four, on the House and the Senate side is apprised of this. But if you look at accountability linkages, they're not just meant to be behind closed doors, but that the public is supposed to have a role in this. So we then, so then the public debate part of Congress arguably is really important. So we know Congress is taking positions, and as Obama said in 2016, his concern was that without Congress taking an interest, you would end up with the president conducting perpetual wars all over the world. So conversely, if they're on the sidelines, the public isn't going to care. So the position taking is, again, kind of that role between the elected leaders and the public. So again, it's this question is, what is contributing to these legislative checks. And so we have looked at, is it partisan loyalty? So are Democrats in Congress more likely to, were they more likely to turn a blind eye during the Obama administration? I mean, there's a sense that that kind of happened, but we want to look at this empirically. Or is this all about negative partisanship, that whoever's in the opposition is going to oppose and act as a constraint on these policies? So here is a sort of separate where we looked at members of Congress and the positions on war to see whether it's about kind of partisan loyalty or negative partisanship. What we looked at on the Congress side was two different surges. So in political science, it's really hard to find natural experiments. I'm not going to call this that, but we had two different surges, one during the Afghanistan war in 2007 and one for the Iraq war in 2009. One was under a Republican, one was under a Democrat. And so it allows us from a kind of empirical perspective to see, is it Democrats who are just doves, whether it's a Republican or a Democrat, or are Democrats acting more, taking more of a constraining role when it's when they're in the opposition and vice versa. So as I said, we've scraped the congressional record. We hand-coded a training set on relevance and carried out machine learning, then iterated. And so we have thousands of speeches that we have coded for whether these legislators were for or against across these two wars. I'll just really briefly, I think, just conclude with some thoughts on the studies we've run. That party loyalty is less dominant. So this is during the Trump administration versus the Obama administration. And we can see generally that Republicans have been more supportive, regardless of who's in office. But the partisan gap is larger for Republicans than it is for Democrats. So their support is only 10% compared to 30% under Trump. And I think what we can conclude here in a way is that when we think about these constraints on the executive and some of the and their corresponding policies, it tells us a little bit about how the prediction would be under a Republican, you're going to get far more support for these policies than you would under a Democrat. But what was interesting here, and this I think comes back to some of these questions about the relationship between events and the media and the public and the policies. So there's a negative relationship. We asked about all drone strikes. So there are tens of thousands when you bring in, the strikes in Afghanistan and Iraq. A negative relationship between people, when you ask people, how many drone strikes do you think we've conducted? And we give these different categories. So people, as the assessed, or what people think of as the number of drone strikes that have been conducted, as that goes up, their support goes down. But interestingly, when you tell people what the actual number is, it doesn't do anything to their support levels. And so you have no information. This is the relevant in the right corner. You have no information about the correct number, and then you give people the number of strikes that they have, that the US has conducted. And there's no statistical difference between the two. And what it suggests is that, or what it could suggest is that these policies are not changing based on changes in public opinion, because those levels of support are the same regardless of new information people are getting about these programs. And I think what it suggests is that partisanship actually is doing quite a bit of work when it comes to the public, and as I show, the members of Congress as well. One last thing on the drones issue specifically in the New York Times, only because I had this figure and I wanted to, it was actually very relevant now. So we did in this second study I was just talking about on legislative accountability. So we through this, the congressional record and the scraping, had aggregated the number of paragraphs on drones in the congressional record. And that's on the left axis. And on the right is on this one here, the average yearly Google Trends popularity of drone strikes, and then the New York Times coverage on the right. And what's very interesting to me is that there's a pretty close correlation up until 2013, when then there's a divergence between congressional attention to this issue and either public interest in the topic and the New York Times coverage. So New York Times keeps covering these issues, but now Congress just checks out. And so I think what that suggests is that these policies tend not to be attracting much attention from the public. They tend not to be attracting much interest from Congress. And I think this actually comes back to some of the earlier work I've done on democratic accountability and drones themselves, which is that the accountability linkages unravel because Congress is more likely to be engaged when constituents are paying the cost in blood and treasure. And I think because that's not happening, I would suggest that this mechanism of accountability has to take place through different mechanisms. And I would just, as a closing, wonder if that's why we're seeing these linkages between the New York Times and the military, because there's such dysfunction in these normal accountability linkages between events on the ground and the public and Congress, the sort of traditional forms of checks on these policies. And so these other ones that Brian identifies then are operating orthogonally because these mechanisms that I have associated with previous wars are less operative in today's wars. So I will close there. Thank you for the few extra minutes of time.
Yeah, Dr. Krebs, absolutely. Thank you so much. And again, I completely understand. I've built a slide. Darn it, I'm going to show it to you. One of the things I find really interesting is your discussion of sort of the public discourse or congressional discourse. When you know that what is being discussed in sort of public view is imperfect information because of classification at the tactical or the programmatic level. One of the things I found particularly interesting with your data on the expected as opposed to the actual number of drone strikes and public support associated with that is whether having the accurate information is apt to change at least the public's minds on a lot of these issues. So I found that particularly interesting. I guess now, I know now, Dr. Williams, turn over to you. And I think the interesting piece here is having been a part of the Tiger team that worked on the Civilian Harm Mitigation Response Action Plan, again, the CHIMRAP, the extent to which you can speak to sort of the policy imperatives driving that and how sort of the vision is that'll impact, DoD operations going forward. So, ma'am, please, over to you.
Great. Well, thank you, Pete. I will do my best to be brief. I have a history of being categorized as a fast talker, but I'll try to do it by carving out or by cutting off words from my discussion as opposed to from just rattling them off at speed. But it's great to be here today, participate in this conversation. I want to start by talking a little bit more broadly about the CHIMRAP, kind of address some of those issues that you just touched, Pete, and then get to a couple of the points that are raised, such as accountability and how external influences have played a role, which have been raised significantly during this conversation. The CHIMRAP really truly is Secretary Austin's plan. It reflects the Secretary's intention to explore ways in which we can improve how we mitigate and respond to civilian harm. And it does this by focusing first and foremost on improving the military as an institution in order to enable greater effectiveness. DoD leaders are motivated both by the moral imperative of mitigating civilian harm and really the criticality of this effort to achieving long-term operational and strategic success. And so with that in mind, the CHIMRAP takes an institutional approach to civilian harm mitigation and response, kind of turning the tables on what's often been felt as an unfunded policy mandate. It sets forth a reinforcing framework of processes and institutions specifically designed to improve strategic outcomes and optimize military operations. And it's critical, understanding that it's critical that we ensure operational commanders are well supported with institutional resources, tools, and capabilities. The CHMRAP then is comprehensive in nature, reinforcing that the DoD's efforts to protect civilians are not just the responsibilities of commanders and operators in the field, but really of all of us across the department as we build the force that we need to approach future conflicts. Importantly, the goal of the CHMRAP is to enable commanders and operators to better mitigate civilian harm while preserving the decision space for commanders without tying their hands or limiting freedom of action, and in a way that's scalable and relevant across the full spectrum of military operations. With that in mind, the conceptual underpinning of the CHMRAP is a focus on the civilian environment, including the civilian population and the personnel, organizations, resources, infrastructure, essential services, and systems on which civilian life depends. So consistent with the CHMRAP, DoD will set forth to define the civilian environment as an element of joint doctrine and take institutional steps to improve the commander's understanding of the civilian environment, including by providing civilian environment teams, for example, at operational commands, who will assist commanders in understanding the effects of friendly and adversary actions on civilians, and by focusing attention within the defense intelligence enterprise to similarly better understand non-adversarial aspects of the operational environment and provide this information to commanders and operators. Essentially, there's an underlying philosophy here: better information, better capabilities to improve better operational outcomes. Likewise, throughout the CHMRAP, the Secretary has directed a number of changes to guidance and processes for responding to civilian harm. These actions are aimed at ensuring that DoD understands the outcomes of operations on civilians, and they are deliberately written to be scalable. For example, understanding that in many conflict scenarios, DoD will not be able to engage directly on the basis of each individual strike to understand the direct outcomes of each tactical action, but the DoD still in those scenarios will require an understanding of the outcomes of our operations on civilians, and that we need to have approaches in mind then to be able to understand what those outcomes are and to respond to those who are harmed. In directing the development of the CHMRAP, the Secretary, alongside other DoD leaders, were very clear that the action plan must apply across the full spectrum of operations. This is not a counterterrorism plan. This is a department-wide plan that needs to be applicable in all future crisis and conflict. By focusing on improving the information and capabilities available to commanders and operators, without, for example, changing our targeting processes or affecting rules of engagement, the actions directed by this plan do just that. The actions are deliberately tailorable to appropriate command echelons, while also creating mechanisms to standardize across the department where it's appropriate. I want to touch briefly, understanding how short we are on time, on two things. One, on the idea of accountability, and second, on the idea of external influences, given the focus really of this discussion today. Accountability is a critical cross-cutting theme throughout the CHMRAP. But within DoD, when we talk about accountability, we talk about institutional accountability as well as individual accountability. On individual accountability, it is quite important that we ensure this, and through the CHMRAP, we'll take a number of actions to improve how we assess and investigate civilian harm, and to clarify guidance regarding accountability measures that are appropriate and available to commanders. But at the same time, civilian harm results far more frequently, not from poor decision-making or reckless abandon or maleficence, but by weaknesses in institutional capabilities and information flow. We therefore consider institutional accountability, and the CHMRAP deliberately adopts a comprehensive approach to better ensure that we're really supporting operational commanders with the tools and resources that they need in order to have these better outcomes. In terms of external influence on the development of the CHMRAP, certainly external influence from Congress, the media, civil society organizations have been important over the past years in bringing to light ways in which civilians are harmed by conflict and raising questions regarding whether there's more that we could do. However, the CHMREP's a DoD plan, directed by DoD leaders, drafted by DoD personnel, which reflects an effort by the department to look internally and to determine appropriate ways in which we can improve outcomes for civilians while conducting military operations. Just to give you a little bit more about our process, the CHMREP was developed by a team of experts from across the department that included representatives from combatant commands, from the Joint Staff, from elsewhere across the department that were identified as appropriate experts by their home components. To inform the CHMREP, the Tiger team engaged with experts outside of the U.S. government, including from federally funded research and development centers, academia, and non-governmental organizations. I know a question was raised on that earlier of whether or not that engagement with civil society happened. It did. I'm sorry, it's not represented in the document, but it has been a focus to make sure that these different ranges of perspectives are brought into our thinking in the development of the CHMREP and in the development of policies and plans and whatnot. However, no one at the same time, like I will say, no one from outside of DoD was involved in the internal process of developing the action plan. The development of the CHMREP was solely the responsibility of the Department of Defense and subject matter experts assigned to the CHMREP Tiger team. Relatedly, DoD did not permit any group or person outside of the government to have access into the internal deliberation of the CHMREP. While we did obviously have similar consultations with U.S. government personnel, especially military operators and commanders, in order to make sure that they gained their insights and had their coordination in the development of the plan. The CHMREP underwent 3 rounds of 4-star level coordination across the department, including a seminar discussion held by most senior DoD leadership, convened by the Undersecretary of Defense and the Vice Chairman of the Joint Chiefs, and followed immediately by an outbrief to the Secretary of Defense and the Chairman of the Joint Chiefs of Staff. These were really important dialogues that we were having throughout the development of this plan to make sure that it really can apply to across the full spectrum of operations across DoD. This discussion is important and it remains ongoing. Already in the early stages of implementation, we're having a variety of internal and external facing conversations to discuss most effectively implementing the CHMREP. It's a very comprehensive document, and at the same time, it's a strategic level document. Many of the actions in there direct things like the development of entire policies or new doctrinal publications or major modifications to existing doctrine. These aren't already baked. These are a process that will require appropriate discussion in order to ensure that we are implementing this in the way that continues to fulfill the Secretary's vision as directed in the CHMREP. I'm going to be cognizant of the time and close my remarks there, given that it's already 2:32, and turn it back over to you, Brian, for discussion.
So at this point, I think we open it up for question and answer to the audience. We have nothing in right now. So while I'm waiting for folks to ask question and answer, again, I ask that you use the question and answer feature at the bottom of your Zoom window. I want to seize on one of the things, Dr. Williams, that you talked about there, which is the CHMREP being a strategic document, not being counterterrorism focused, and really being applicable to the range of military operations, from large scale combat operations down to counterterrorism and the like. So I did not offer this, right? I am an active duty Marine. I am not here. I'm here speaking in a personal capacity. My views do not represent those necessarily, the United States Marine Corps, Department of Navy, Department of Defense. With that being said, one of the struggles that we have within the Marine Judge Advocate community, in my estimation, and in the other services as well, is retraining folks after 20 years of counterterrorism to think about conflict through a different rule set. And understanding that if there were an international armed conflict, the Marine Corps, right, pacing threat is China. That's sort of where our focus is. But if there's an international armed conflict, where is the rule set different from what we've seen for the last 20 years of counterterrorism operations? Where is it more permissive, maybe in terms of proportionality, which is a thing that I think makes people a little bit uneasy? And then where's the rule set more restrictive? And I think I would pose the question, both to Dr. Krebs. I understand that she's got to drop off probably the earliest, right? But in terms of public discourse and the like, if this is a struggle that we have within our own uniformed legal community, and it won't surprise me if we also have a similar sort of disconnect or difficulty kind of understanding the different rule sets as you move, maybe not necessarily higher up the chain of command within the department, but into Congress or the like. What impact do we think that has on shaping policy if folks aren't just even discussing the rules of the game properly? And then I would ask Dr. Williams to maybe follow up on that and say, you mentioned that this is intended to, the CHIMRAP is intended to address kind of the range of combat operations, right? So to what extent y'all were having those discussions about, here's how the rule sets vary, here's where, you might have more maneuver space, here's less, right? And those sorts of things. So I'll stop talking. Dr. Krebs, to you first, if you have, I'm sorry.
It sounded like it was for Dr. Williams.
Okay, well, I guess she can go first, but then I'm curious about the shaping public policy if we're not even having a conversation where everyone understands that the rules of the game might be different if we're talking about conflict with a state actor as opposed to counterterrorism. So it's Dr. Williams, to you first, but then Dr. Krebs, to what extent we can have those public conversations. Over.
Sure. These were really important conversations that we were having throughout the development of the CHIMRAP. We had members of our team who were coming from, UCOM and DPCOM and thinking about things in a quite different operational context than some of others who had been really involved in more recent operations. The scalability question is huge. It's very important here. If you look through the CHIMRAP, you're not going to find objectives that speak to ROE. You're not going to find objectives that speak to how do we make decisions about proportionality. You're not going to find or actions that change targeting protocols in any way like that. What you're going to find is a focus on the civilian environment and understanding it and making sure that information is available to commanders and operators. You will not see you must have a 4-hour scan over a target by whatever ISR platform in order to conduct a strike, but we will see dedicated effort over time by the institution to develop that understanding of the civilian environment that's appropriately tailored to that context in advance of that conflict, so that that information can be used to inform the commander's decision making. Essentially, the underlying philosophy here is that commanders are making the best decisions they have with the information they have available. We are not changing the rule sets by which they're making decisions. We're making different information available to them, ensuring that in addition to understanding the adversarial aspects of the operating environment, they have a full and robust understanding of the full environment, which includes the location of the civilians and the ways in which civilians depend upon essentially where they live, the goods and services of where they live.
Thank you. I think that's very helpful. So Dr. Krebs, to you, and then we do have a question. So Dr. Krebs, to you for the previous question I asked, and then we do actually have one submitted now. So I'll ask that next.
So I understood your question, Peter, to be about the public and how it can be weighing these policies, or no, what was the crux of it? The public
I think the crux of it is whether the public and I think in context of this conversation, Congress and some higher level policymakers are to the extent they don't have an accurate view of how the rule set differs between an international and a non-international armed conflict. How do you inform that? And does it matter?
I'm pretty pessimistic on, just, the last 15 years of my work that in some ways touches on the public suggests that the public is not, that these issues are just not salient for the public. And I think that has to, again, it comes back to democratic peace theory, which is what mobilizes the public. It's when they see the cost of war in blood and treasure. So we don't have taxes for wars anymore because we're paying for wars through debt, and we don't have as many casualties because we're using drones, and that's, you know, generally a good thing. But if you think about these accountability linkages, what gets the attention of the public, those aspects of war are not a real feature of how we are doing counterterrorism operations anymore. And so we need, and that then feeds to legislative accountability as well, which is if the public's not concerned about this, why would Congress waste its time on accountability? And so I think, and you know, just one last thing, because we have an election tomorrow. When you look at the top 20 most important issues that Gallup covers, or that they ask, you know, what are the most important issues that you face? Foreign policy is nowhere on there. No, not even the Russia-Ukraine situation. So to suggest or to think that the public would be able to parse those differences, I think really gives a little bit too much credit to the public. So I think, again, that there needs to be, that we need to rethink accountability linkages, because those mechanisms running through the public just aren't present. So I think that's a longer conversation, unfortunately, but I think that the public is probably not the mechanism of influence and accountability that it should be.
Thank you for that. And then Brian, I understand that you have something that you'd like to say.
Yeah, so I'll be really brief. I know that we'll try our best to maybe wrap up by 2:45 Eastern here if we can. So really briefly, I think the key takeaway on the difference between, say, COIN and large scale combat operations is that in a COIN environment, the center of gravity is understood to be the civilian population. Whereas in a LISCO environment, say, you know, the conflict in Ukraine is a good example, the adversary is the center of gravity and their capability to continue the fight. And so we have to keep a focus on that, you know, in our public discourse, and then also moving forward with CHMRAP. One of the great things about CHMRAP is, as you mentioned, Dr. Williams, it keeps space for, you know, it's not too directive. So it's flexible and it's scalable, and that's fantastic. But moving forward, as we implement CHMRAP, we'll have to keep in mind the big difference in the center of gravity and how that affects combat operations. There were plenty of targets that, for example, in Afghanistan, in a combat environment, that we just flat out didn't take a strike, or we took a lot of time to decide on the strike, and we ended up either maybe engaging or maybe not. And we won't take that, the considerations and the time factor will be much different in a LISCO environment that we're not used to operating in, but we need to be, when the center of gravity is the adversary and their capability to continue fighting rather than support of the local population.
Thanks, Brian. Actually, so interestingly, I think that ties very nicely into our first question from Mark Galasco. Essentially, I don't see why large-scale combat operations, LISCO, make protection of civilians more problematic. We've seen what happens when you don't protect civilians in Russia's failed war. Does LISCO not require you follow the laws of war? Distinction and proportionality don't end with COIN. So I would pitch that, Brian, to you, and then Dr. Rondeau to you. And I think for my purposes, what's important is to highlight the ways in which those concepts are still applicable, but different.
Yeah, that's right. So, Mark, your point is very well taken. That the, you know, LOAC is the same regardless of your operational environment, and you know, protection of the civilian population is, you know, that doesn't go away, and it's just as important. And I think that's a fantastic point to raise. I think the difference is that if we're used to operating in an environment where, say, you know, and this is public, you know, public knowledge that the tactical directive didn't allow for basically any foreseen civilian casualties in a conflict in, say, in Afghanistan, where the prospect of the potential for civilian casualties and the operational acceptability of that will very well be different in a LISCO environment. And so the constraints that we'll place on commanders in a more of a COIN environment will be different in an environment where the civilian population is the center of gravity, whereas the adversary is not necessarily. But your point is absolutely well taken, and thank you for that, Mark. The LOAC doesn't go away, and you know the imperative to to protect the civilian population is the same in either context. It's just a matter of the operational constraints that we'll agree to place on commanders. And commanders and personnel, to be quite fair, are not used to the LSCO environment. We need to get there.
Dr. Rondeau, did you have anything to add?
Yeah, I'll be very brief. Along the same line, so I think it captures most of the element. Dr. Williams mentioned the new focus on civilian environment. I think that's the anchoring point. The rules remain the same, LOAC remains the same. The context is different, and that's what's so useful with those rules that have been, adopted in 1949, but developed way before that. And the context keeps evolving, but we still have those same rules. And those rules that I think I just want to address. We did have a question that came very early on by Marla Keenan, and talking about the other actors, so not necessarily just D&D, but all the others actor in government. And I think that's the common element. Looking at it from an IHL or an LOAC perspective, that's the common language we have with justice, with foreign affairs, with other interlocutors in the government. That's where you can actually say that the rules will remain the same. The way that you apply them will be different. And that's why you need that interaction with civil society. So Dr. Williams, thank you for mentioning that civil society was part of the drafting. So that's an important element to consider. But that's the language that you can actually anchor everybody around it. So I think the urban setting, armed conflict, maybe we should not go into that discussion 15 minutes after the end of the conversation, but from an IHL perspective, it's not IAC and CT. It's IAC and NIAC. So there's international armed conflict, non-international armed conflict, and then counterterrorism it needs to find a place in there. And it's also a concept that comes from the international community. So it's United Nations, and United Nations will also give that prevalence to IHL, and we'll need to protect humanitarian space, but also protect that environment within situation of armed conflict, be it international or non-international, or even situations that are not under IHL. You still have those counterterrorism measures that needs to apply to it. So I think that discussion opened more door than closed some, but for me that's very interesting to see all of those areas kind of interconnecting into one. So I'll save my comments to that at this time.
Thank you very much. We have one other question, and Dr. Krebs, I know you've got to go, but this seems like it's squarely pointed at you.
No, I'm just late for a meeting already. So I was, I thought you guys were military people, like sticking to time here. So I'm really sorry. But yes, I can do a really quick response if it clearly is directed to me.
Jenny McAvoy asked, should we be conceiving of the public more broadly, for instance, beyond domestic and in terms of global public opinion, potentially now having a more significant influence on U.S. policy?
I think that's a great question that comes back to ACIL. And I'm reminded of Harold Koh's speech in 2010 to ACIL about drones. And it was to the international legal community. The public didn't care. There were no public opinion polls at that point about drones. And I think when you look at all of the statements, and again, I'm just here thinking about drones, but if you look at all of the statements Obama made at the end of his term, it was all about the international law community. It was about Human Rights Watch. It was about Amnesty. It wasn't about the public. And so I think that's a great question that's really kind of consistent with a lot of the evidence that we have actually seen in the last few years.
Dr. Williams, anything that you might have to add on that point, or?
I mean, I agree that I think that the idea of the question was originally directed at the legislative point there. But I think just in general, to a couple of the points that have been made, there very clearly is a whole of government aspect of this, where we bring in information from varied sources to inform our operations, and there's various representation across the U.S. government that has a role in different elements of civilian harm mitigation and response, whether it's bringing together information on the civilian environment, as we've talked about a lot, whether it's how we respond when civilian harm occurs, and using different tools and different authorities across the U.S. government in order to facilitate response, or we haven't talked at all within this forum about how we work in multinational coalitions or with non-state actors or through our security cooperation programs and partnerships to to facilitate civilian harm mitigation response in various operational contexts. But that is a big piece of the CHIMRAP as well, focused on 2 objectives in particular. And so you'll see other U.S. government elements of that too. So it's just one thing, I've noticed a couple of questions with regard to U.S. government as a whole, and a couple of comments with regard to U.S. government as a whole kind of come about here. I think that the role of Congress and the role of the other elements of the executive branch in kind of in continuing to evolve the U.S. government's approach to civilian harm mitigation and response, and including in response to some of these public concerns and external influences is something to continue to explore.
Dr. Williams, thank you very much for that. So I will use my moderator prerogative and I will wrap up. I'm cognizant of Dr. Krebs' time in particular. So I just want to say, well, I'm a Marine, so it wouldn't be appropriate for me to not discuss Secretary Mattis, former General Mattis, right? Who told a group of operational lawyers once that, you guys do some really good sort of intellectual analysis, but you tend to be very narrowly focused. And I think the narrow focus that he's talking about is you think about things from your hat as a lawyer and you think in terms of legally objectionable, not legally objectionable, and that's it, right? And I think the benefit of having a panel with this representation is we get to hear a host of different views from, former uniform practitioners or, from a uniform myself, but also folks who work in policy, folks who work in academia, folks who work from the non-governmental organizations side. This has been fascinating and highly educational for me. As I said, we scratched the surface. So unless anyone else has any closing comments they feel they have to make, thank you all very much for your time. Thank you to all of our attendees. Thank you to Cornell Law School IT Department for hosting this webinar. I greatly appreciate it. Thank you very much.
All right. Thanks, everybody. Bye.
Thanks, everyone.